Our next presenter is already with us here. It's close to 2:30 p.m. and yet we would like to redeem on time and be able to conclude in time. We are already out of the program by several hours, so I will request that we take our seats and we move forward. My Lord, the Principal Judge, we have 3 presentations this afternoon. The first presentation is a presentation of the Judicature Cases of Persons with Disabilities Rules 2024. That will be followed by a presentation of the Constitution Operation of Mobile Courts Practice Direction 2024. And lastly, proposed amendments on enhancement of pecuniary jurisdiction of magistrates' courts. Our next presenter, Honorable Justice John Ketirima, is here. And the next presenter, our Worship, the Chief Registrar, Sarah Langasiu, is also here. I'm sure by the time we are through with the first 2, by God's grace, Honorable Justice David will be here, and if not, Worship, the Chief Registrar, will still take us through. So allow me to invite Justice Ketirima to take us through the next presentation. My Lord, you are welcome. Honorable Justice David Wangutisi is online, and he will be moving with us as we proceed. Thank you.
Thank you very much. I intend to be very brief because the rules are also brief. And I know that after a sumptuous lunch like we have had, the digestion process is still ongoing, and therefore our levels may not be at best. I'll just project the rules as they are, but maybe to say that Article 35 of our Constitution provides that persons with disabilities have a right to respect and human dignity, and the state and society shall take appropriate measures to ensure that they realize their full mental and physical potential. So we shall now look at what these rules intend to do to realize that constitutional provision. And I'll be flagging off just a few provisions. One is the interpretation. When we are talking about accessibility, when you look at the interpretation section, we are talking about accessibility, which means the possibility for a person with a disability to reach a place and maneuver with it, use a service, receive information used by a public place or service, and participate in the activities provided by the public place or service. on equal basis with others, with dignity, independence, and safety. So we are not looking just at the physical ability to access, but we're also looking at the services that should be available to a person with disability. The other important definition is communication. How do we define communication? Communication includes languages, display of text, braille, tactile communication, large print, accessible multimedia, as well as within audio and plain language, human reader, and argumentative and alternative modes, which means the formats of communication including information and communication technology. So we still are bound by technology here. We are not escaping it in any way. And in any case, it's still available for even people with disability. The other definition I wanted to flag off is what do we mean by a person with disability? It includes persons who have a long-term physical, mental, intellectual, or sensory impairment, which in the interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. Because I know there will be instances where there are challenges in defining who a person with a disability is. At times people look physically fit on the face of it, but they will tell you they are disabled and they want to be treated as disabled people. So this gives us a guideline on how to define a disabled person or a person with a disability. That's the right language to use. The rules are now introducing what we call a support person. That's also something I want to flag off. And a support person means a person appointed by a person with a disability appearing before the court to support that person with a disability as they make decisions and choices about their matter before the court. So it's now possible for somebody with a disability to say, I want my mother to be around. She understands me better. She knows how support I need. I want my father to be around. I want my brother to be around. So the court has to bring on board such a person to support this person with a disability. Now, of course, the objective of the rules was to provide for the practice and procedures of the court in connection with hearing and intended hearing of cases involving persons with a disability in courts of law. We've had many complaints about the physical access of our courts and how we treat these people. And I think these rules are there to address some of these problems. For example, if you look at accessibility of the court premises and information, that's part 2. It's now an obligation, it will be an obligation, that every judge or magistrate hearing a case to which a person with disability is a party shall take all steps to ensure that the courtroom and services provided therein are physically accessible to the party with a disability. And in cases where the courtroom is physically inaccessible, either due to structural design or otherwise, the court shall find an alternative venue to enable the party with a disability to be physically present. So if in my wisdom as a trial judge, I believe that the facilities in the family division where I work cannot be easily accessible after an initial assessment, and they can be accessible in Hotel Africana. It's now within my discretion to make that decision for purposes of enabling this person to access the court. Things to do, for example, say with toilets. I'll give a basic example. It's quite common that our facilities do not provide for people with disability. And you know, some of these hearings can take long. So that can be a factor. If an advocate is presenting a person with disability, physical disability, they can say, I have looked around the toilet facilities here and I don't think they are ample enough for our clients. Of course, that comes with a financial implication, and therefore I can see a lot of pre-trial hearings to address some of those problems. Maybe those will be done at the summons for directions. Amongst the guidelines, I think the registrars will have to guide the court if they are dealing with people with disability on the facilities that will be required, or advise on the venues that the hearing can take place. So that also does with reasonable accommodation at 6. We shall skip that. The question, determination of disability at 8. Whenever a question arises as to whether or not a person is in fact a person with a disability, or for purposes of proper administration of justice, court shall seek services of professionals, including service providers, social workers, medical persons, and persons living with that person on whom a determination of disability is required. Some people have, for example, back problems. I don't know whether to describe those as people with a disability. Because at times, as a party, you're expected to stand in the witness stand for quite some time. So I don't know how they will be described, but if somebody, for example, says, I cannot stand for quite some time, and this is the type of chair I require, then for purposes of that trial, you may have to give a definition, or whether this person actually fits within that definition. So I can see many applications being brought to the courts. Now, if we go to part 3, and I said these are some of the things that can actually be determined in the pretrial processes. For example, when there are summons for directions, I think the registrar should be informed about those necessities that the court may require to handle such a trial, so that by the time the matter comes to the judge, they are able to know what they are dealing with. Now, if you look at part 3, criminal matters, pre-court procedures. The court shall inquire into the circumstances under which a person with a disability was arrested to establish whether or not the arrested person was offered the opportunity to access the services of a sign language interpreter, a support person, a guide among such other services as a person with a disability may need. Now, this also requires that we'd have to look at all the police stations that are involved in the criminal justice system. There should be a review on whether they have the capacity to treat this type of people, on how to handle them. Because once there is a preliminary objection raised that the procedure did not put into regard the disability of this person, those proceedings can be, or the charge sheet can be quashed, as you can see. If you look at subsection 2, it provides that where the court establishes that the arresting officer did not provide any such services in sub-rule 1, and is of the opinion that the accused person needed such service, court shall quash such statement and make appropriate orders. Again, I see a lot of challenges in the criminal justice system that will have people of this kind, because it presupposes that our police stations have the capacity and they will need a lot of training, especially with compiling, with regard to these rules. How do you treat a person with disability? What services do they need? What should you provide? And the question is, will they have the capacity to make provision for those services? That's a question, I think, for somebody else to answer. Ability to stand trial, to participate in the court processes. It makes a lot of referrals. Capacity to determine whether somebody is with a disability. If that question arises, again, a question has to be set for an expert to determine in order for the court to proceed. So I will not go into those processes. I think that is a detail which is not for us, only that it highlights what the court or guides the court on what they should do once they are encountered with that problem. And that takes us to page 9, because this is something I want to emphasize. We've heard about support persons in criminal matters. If you look at 11:15, it provides that before commencing the hearing, the court shall at all times provide the suspect the opportunity to nominate not more than 3 people to act as support persons for the suspect with a mental disability. Again, that has a financial implication now on our sessions. All the accused has to do is to appoint these people. So I need my mother, I need my aunt, I need my brother. Those are requirements I need for this trial. And therefore, the court should be able to provide the logistics to ensure that these people appear throughout the trial. That's, I think, one good innovation, but that has a serious financial implication. Now, 12, inquiry into pre-trial processes. The court is now obliged to inquire into circumstances under which a person with a disability was detained to establish whether support services and accommodations were offered to the person. Where they were not provided, the court shall take this into consideration while considering the accused's application for bail, or where bail application fails, court shall provide proper guidance on where and how the accused should be remanded. Again, that is a challenge to the courts, in my view. Where are these alternatives? Are they available in the system? If I find out, for example, that the prison facilities cannot keep this person, which alternatives do I have as a trial judge? Can I recommend a hotel and ensure that this person is properly kept in custody? Those are the practical challenges, but the rules are now available that gives discretion to the trial judge or judicial officer to make provisions. Now, the rest of course 13, 14 are still processes. Go to 16, committal procedures. Bail, we have talked about bail this morning. And now it's a requirement that the court shall take into consideration one's disability as a ground to grant bail. If somebody says, I'm disabled, that is also put into consideration. And an accused person shall not be denied bail solely on the grounds of his or her psychosocial or intellectual disability, as long as evidence has been produced to show that he or she is in stable mental condition and as substantive sureties who shall ensure his or her attendance or notify court about his or her condition. Considering disability, there are people who are disabled on arrest, like the recent case we saw in the press. Would somebody be able to hide behind that provision or to invoke that provision of the law? I was disabled after arrest. But he's disabled and is physically disabled. So when you are granting bail, you have to take that into consideration. Now, if you look at examination of witnesses, again, these are processes. There is something brought about, especially with the identification parade. You know, the purpose of the identification parade was for a victim to visualize and see whether that was the suspect that offended him or her. But basing on the disability now, it will be admissible evidence to allow this witness to use other senses of perception, including touching. There are victims who are visually impaired, so they can now be allowed in an identification parade. Was this the person who assaulted you? Can you? I don't know how this will be done. By voice and by smell. Yes. Apparently, by the way, there are people who use other senses better than, especially if they are impaired in one sense. Somebody can be able to say, this is how the accused, this is how he smelled. And using an identification parade, I can be able to point out and say, this is the smell. That evidence is now admissible. Okay? Or I could touch. Could touch the beards. I could touch the size of the head, depending on how you encountered the accused. So in other words, we are saying we are not limiting this to visual identification. If this witness is able to say, I can identify this person by other means, then that evidence should be considered. Let's go straight to sentencing. Again, another challenge to the justice sector. As I've already mentioned, when it comes to sentencing, the court shall ensure that before a custodial sentence is given to a person with a disability, the detention facility shall be in such a condition that would enable the prisoner with a disability to exercise his or her rights on an equal basis with all others. Do our prison facilities actually have provisions for people with disability? But they are saying you have to put that into consideration when you're sentencing. So that means the way forward is that we should interest all the justice sector's institutions when they are constructing their facilities to put this into mind. To know that the offenders who will be people with disability and make provision for them. And these are basics. For example, as I've said, places of convenience, that's a very big consideration. Even for purposes of bathing, you have to have those facilities in place, basic facilities. Otherwise, the court will have every reason not to send somebody to prison. Now, part 4, civil matters. Again, a logistical challenge for the courts, but which has to be done where it's established, when you're effecting service of court process, where it's established that a party to a matter has a disability, court shall, as much as possible, ensure that court process is served in a manner that complies with the accessibility needs of that person being served, taking into consideration the person's unique disabilities. This calls for recruitment, or even calls for the capacity for the court to outsource these services where they are not available. How do you effect service, for example, on a blind person? What type of documents are you presenting to this person who has been sued? Again, that's about the capacity of the courts, but I'm sure with these rules, there is also always a financial implication, and therefore the court must provide. However, now, what maybe may assist court to plan is that now there's a provision under 25 that where a litigant wishes to receive disability support or reasonable accommodation during a hearing, he or she shall disclose in a paragraph in the plaint or notice of motion or in their written statement of defense the kind of disability and the support or accommodation he or she requires. So it's now a requirement in your proceedings, if you want to be assisted, to explain the nature of your disability and what you think the court should assist. This gives the court ample time to prepare for you. And therefore, you are given adequate notice on to marshal the resources in order to ensure a fair trial to this person. And of course, we also look at execution. 27. Even at execution, the execution orders by a judge or registrar shall be served and executed in a manner that takes into consideration the judgment's date as disability. An execution shall not be undertaken with regard to property of a person with an intellectual or psychosocial impairment without fully engaging their support persons who will explain the nature of the process to be undertaken. Well, I thought this provision was redundant. By the time you reach the stage of execution, you would have known why you're being executed against. But still at execution level, it's a requirement that you will need the support of these support persons. So basically, the rules are about physical access. The design of the courts has to be changed. The facilities the court are to use are to be considered, and the services that the court can now provide to this category of people is a thing the court now must consider. And I'm sure with these rules, there will be a budget that will make provision for this facility so that we make justice accessible to everybody. And that is my brief presentation. I thank you for listening to me.
Thank you, my lord, for that presentation. We are going to have the next presentation, and this is on jurisdiction. And I beg to invite the Honorable Chief Registrar, who will inform us how it shall be done. And we have Honorable Justice David Wangutusi online, who is a co-presenter on this subject. I worship, you're welcome.
Thank you very much. My Lord, the Principal Judge, Justice Wangutusi is going to kickstart the presentation on enhancement of jurisdiction, and then I'll come to wrap up the other part and then proceed to the last. My Lord Justice Wangutusi, you're welcome to proceed.
Justice Wangutusi is logging on, and as soon as I get the thumbs up, we shall be able to have him. We also had a few challenges with the hackers, and the team has managed the situation. You could have seen some people in the waiting room. Those are some of the people we served with the rejection notices. So, so we had also to take on electronic management. Otherwise, they were also distorting our recording system. We're almost there. So Honorable Justice is inside the room, and so is going to be allowed on, and we proceed with him. My Lord, you are in. Senator, is it the waiting room management policy now? Okay, let the Chief Registrar be taking us through.
Thank you very much, my Lord PJ and my lords and all participants. I will be starting as Justice Wamtusi tries to make his way into the room. Justice Kiriabuira, you see the challenges of these issues. From the onset, it's telling us where we are going may be tricky, but we will get there. Okay, so I'll start us off on the issue of enhancement of jurisdiction of magistrates' courts. And what Justice Wangtusi and I are meant to do this afternoon is to take us through a discussion, particularly concerning the amounts. Because what we can all agree in this room is that the debate or the requirement to enhance this jurisdiction is already settled. Everybody is in agreement, all stakeholders are in agreement that we need to enhance. The only question is to how much. And before I go into the proposed amounts, of which we have 3, because a study has been done, and the first study started in 2021, and the second one that concluded it was done in 2023. So we have 3 proposals that we are looking at, and we will show you how those proposals play out. But just as we start, what is our caseload today? As we speak, we are at 156,349 cases that are pending across the entire judiciary. What is the backlog? We are at 42,960. Of all this caseload pending and backlog, how is the High Court performing? The total caseload at High Court is 63,402, and the backlog is 24,836. Right now we have 79 judges. If we took an average, it means 802 cases per judge. How are we performing at the magistrates' courts? The total caseload is 108,209. The backlog, which is before the chief magistrates and the grade 1s, is 11,313. Combined, if you combine the chief magistrates and the grade 1s, as we speak this afternoon, there are 459. Of these 459, we have 91 chief magistrates and 368 grade 1s. So if you go by the average of the 108 cases to the 459, you would put it at 235 cases on average for an officer of the lower bench. So the studies that have been done, and there's a particular table that when Justice Wangutusi comes, he will project the 2021 table. I want to take us to the table that is going to show us the proposals. The first proposal is to enhance the chief magistrate to 200 million. That is from 50 million to 200. That is 2021 study. And Justice Wangutusi, if he comes on board, is going to show us. I'm sorry, I'm not running you through that entire report. I'm going to show you particular tables. The second proposal is enhance the chief magistrate from 50 million to 100 million. And the last one is enhance the chief magistrate from 50 to 75 million. We are going to show you the effect of each of them, and then we shall decide where are we going. So let me take you through the 100 million. What 100 million does for us, and I'll request the person that is running us to take us to table 5. As it takes us to table 5, we are giving you statistics that come from 3 divisions, that is commercial court, land division, and civil division. For some courts, we have not yet concluded unpacking the subject values of each of the cases. And we take you through 11 circuits. That is Arua, Jinja, Lira, Masindi, Mbale, Luwero, Rukunjiri, Kabale, and PG High Court. Overall, if we take a chief magistrate from 50 to 100, and we take a grade 1 magistrate from 20 to 50 million, we shall offload the High Court by 63%, and therefore meaning High Court will be left with about 37% of what they have. So those are let me have table 5. It's a long table. Table 5, please. So table 5 will show you the caseload at commercial court. The ranges we provided there are cases which are cases from below 25 million, because of course some are appeals, some are revisions. We have the cases running from 25 to 50 million, 50 to 75, 75 to 100, and then over 100. When you get to that table, for commercial court, when you get to that table, I'll continue as the table comes. You will find that Commercial court, in terms of the cases that are over 100, they have 3,305 cases. And so of the figures that we had at the time of the study, commercial court will be left with 64% of its cases because it's a high value court. Most of the matters have big sums of money. That's why we have 83 trillion locked there. So they will keep 64% of their cases. Of their cases, 1,577 will come down to the chief magistrate, and about 5.4 of the cases that are there will go to the grade 1. Come to the land division. Now, land division, you'll find very interesting statistics there that the bulk of the cases in land division, and one may wonder whether the values that the advocates or parties declare when they file, whether they are correct or not. But you'll find that many of their cases are lying just after 50 million to 75, and then to about 100. If you go by face value of the land division files right now, you will offload land division of 6,416 cases. And you will leave that division with 2,125 cases. So the question is whether our values that we declared as we filed were correct. So that means at land division, you leave them with 23.1% of their current caseload. 75.4% will go to the chiefs, and about 1.4 that remains will go to the grade 1s. Come to civil division. Civil will retain 53% of what it has right now, which translates to 1,795. 37.4% will come down to the chief, which is 1,261. That is how the 3 divisions are faring. I will sample the circuit so that once that document, that table will be projected, you will look at it. If you go to, let me go to Ginger City. Ginger City, again, High Court will remain with 11.2. They will remain with 181 cases. Those are the cases that are over 100 million. Otherwise, the 1,351 cases that they have fall between 50 to 75 million. And so you will offload Ginger High Court by 86%. Let's go north. Let's go to Lira. In Lira, you will leave the High Court with 32.3% offload, and so it will remain with 384 cases. You will offload it of 59.7%. 709 cases will come down. Let's go down to Kabale. Kabale, the High Court will remain with 40.6, which is 129 cases. 51.3, that's 165, will come down to the Chief Magistrate's Court. And lastly, let me deal with Mpigi on this one. Mpigi, the High Court will retain 26.3%, that is 261 cases. And then 73.7, that is 733 cases will come down to the Chief Magistrates. So, of all the cases, the grand total of the 11 circuits, the 3 divisions that were sampled, if we go by the total there, yes, we will have those divisions and those circuits remaining with 37%, which is 9,993 cases. The offload to the Chief Magistrate's courts will be the 57%, which is the 15,146, and about 6% going by case values will go to the grade 1s. So that is scenario 1, where a chief is enhanced from 50 million to 100, and a magistrate grade 1 from 20 to 50 million shillings. The second scenario of enhancing the chief magistrate from 50 to 75 and the grade 1 still from 20 to 50, that one is also there. This one overall, those are the different numbers, but we can just go to the end of that table so that we present the final position where we are leaving the High Court with about 50% of the next table. So High Court will remain with about 50% when we have the enhancement of 50 to 75 and 20 to 50 for the grade 1 magistrates. It gives us, let me get the actual percentage just here. So with that one, you will have the High Court remaining with 50% of the work, and then the 50% comes to the magistrates' courts. I don't know that Justice Wangtus is here to talk about, is not yet here. Okay, so the other table is on another report. Kindly show us that table that talks about the proposal of 200 million. You can show us table 8. Now table 8, that is 2021, the position we had at that time. We were looking basically at Arua High Court, Lira, Fort Portal, Jinja, Commercial Court, and Mbale. At that time, the proposal was at 200 million. So you would look there, if you added the figures of 200 million and above, Arua High Court would be left with about 40 cases, and the rest would go down to the magistrates' courts. So those were the sampled courts for 2021, which presents that if we gave the magistrates' courts the 200 million, certainly it would have the biggest impact in terms of offloading High Court of over 85%. But remember, 2021, we did not have a new structure that we have in the judiciary now that is expanded, where we have more magistrates. We also have more high courts right now. In 2021, we had the 20 circuits. Now we have 38. 24 are operational. In 2021, we did not have the instrument of magistrates' courts with the chief magistrate in every district. The new instrument is taking care of every district with the chief magistrate when recruited, every constituency with a grade 1, municipal courts running, every city having a chief magistrate. So the position that we believe will work best for the judiciary and for all of us as members of the justice institutions and the public that we serve is the 100 million for a chief magistrate and 50 for a grade 1. I thank you very much for listening to me. So since I am the next presenter on the shortest, Justice Ketim, I thought his was short, but mine. Shorter, yeah? It is shorter. Only 3 parts, mobile courts. Oh, Justice Wangtus is here. Thank you.
Hello? Yeah.
My Lord,
I've been having a problem accessing.
you can speak to us. Unmute the microphone, my Lord. My Lord, unmute. No, you can. Chocolate. Yes, my lord. Thank you, my lord, for the guidance. Let us proceed with the
Yes.
mobile courts.
We are with mobile courts, and the Honorable PJ made my life very easy, not difficult, very easy in the morning because he gave an overview of these mobile courts. We are going to serve our people in the remote areas, and just in case you're still having thoughts on why these courts, you try going to a refugee settlement, and then you'll know how people need justice there and how they are hungry for it and how we must take it there. So we are now on the practice direction for mobile courts, which is very brief. It has only 3 parts and only 10 paragraphs. We will run quickly. Part 1 are the preliminary matters, but what's important, I hope they can project the same, is the objectives. We have 5 objectives. The first one being to take justice nearer to the people in every corner of Uganda. Number 2 is to improve access to justice for the population, especially in remote areas. The third one is to provide easy access to justice to refugee camps, refugee host communities, and distant places from the court infrastructure premises. The fourth objective is to enable the operation of mobile court vehicles by the judiciary. And this is what the Honorable Principal Judge was talking about, what he saw in Temeka in TZ. The fifth one is to strengthen the existing processes of administration of justice to enable speedy delivery of justice. At paragraph 4, what is key for us is to understand that the court here means the Magistrates Court and the High Court of Uganda. It is hoped that especially when we have that mobile court vehicle, a judge can comfortably go and hold a high court session, perhaps in some of these refugee camps or remote places where judges have never been seen by our people there. The definition of mobile court is important. It means a formal court that conducts proceedings in different locations other than their court premises, typically in remote areas where no justice services are easily accessible, and includes the use of mobile court vehicle. It also means the stationing of a magistrate's court or the high court in any place in Uganda for a specific period of time for purposes of adjudicating both criminal and civil matters. At part 2, we are talking about the establishment of mobile courts. Paragraph 5 talks about the establishment and style of mobile courts. And the paragraph there is saying they shall be established to be operated a mobile court which shall conduct court hearings and court proceedings in any place in Uganda, especially remote places, including the refugee camps, the host communities, and distant places from the court infrastructure premises to provide easy access to justice. How will it be operated? The mobile court shall be operated for purposes of conducting court hearings in both civil and criminal matters by a magistrate or judge going to station in a particular place for a specific period of time. And practically we've had magistrates, especially those in the refugee host districts like Ajumani, once in a while they go to these camps, but they need to be properly guided by practice directions. The second one that is new is the taking and stationing of a mobile court vehicle in a particular place for a specific period of time. And the Honorable Principal Judge already told you what that vehicle contains, the entire court basically moving, and so you find a dock, a witness box, and everything that is needed in there for a court to sit and do its work. The proceedings of mobile courts shall be as valid in every respect as if they had been held in a courthouse assigned for that purpose. At paragraph 6, we are talking about the constitution of courts, and the provision here is that a mobile court shall be deemed to be fully constituted when presided over by any judge or magistrate lawfully empowered to adjudicate in the court. How about the administration of these courts? That is 7. The principal judge in the case of the High Court and the chief registrar in the case of magistrates' courts shall take lead in the administration of mobile courts. And 2, a judge, a registrar, or magistrate in the jurisdiction where the mobile court will be conducted will have a delegated role to assist the principal judge and the chief registrar in administering the mobile court respectively. So just as the other courts are administered, these will also be administered. The last is part 3, which is about jurisdiction and guiding principles. Paragraph 8 is on jurisdiction. So subject to any other written law, a judge or magistrate presiding over a trial or cause in a mobile court shall have the same jurisdiction to hear a civil and criminal case accorded to the judge or magistrate, for the judge as per Article 139 of the Constitution, and to the magistrate as per the Magistrates Court Act and other relevant laws. The principles that will guide these courts are from the Constitution, Articles 126 and 128, which I will not belabor on. And lastly, at paragraph 10, we are having the rules of procedure, and the point here is that the rules of procedure that judges and magistrates apply in the ordinary courts are the same ones that will be applicable to the mobile courts. Thank you so much.
Let us add another hand clap for the Chief Registrar for ably handling both presentations. And Mr. Senabulia, as long as we are still waiting, like have a seat about Justice Wangtus. My Lord PJ, we have had 3 presentations, and it's up now time for reactions, comments, contributions, etc. So I would like to invite you to raise them. Yes, I didn't capture the name. You will introduce yourself, Madam. Okay, can we have the ACs regulated better? It's getting hotter. Okay, please proceed.
Thank you, Your Worship. I'm Nancy Awori, and I'm a Principal State Attorney with the Attorney General's Chambers. My comments are on the cases of persons with disabilities. I sit on the National Council of Persons with Disabilities, so this is a long-awaited rules. I have a few comments. One is that I see the rules were drafted in 2019, and based on the National Council for Disability Act of 2003. Since 2019, we have a new law, the Persons with Disabilities Act 2020. So most of the terms being used here, we no longer use them at all. So we need to reconcile the rules and the terms especially with what is in the new law. We also don't have the National Council for Disabilities. The council is now called the National Council for Persons with Disabilities. So, and also the definitions here just need to be aligned with the definitions provided in the new law, because that one was based on the convention. That said, there are certain things that I also request that the rules should address. For instance, providing assistive devices to persons with disabilities, interpreters, using court-friendly and simple language while handling cases of persons with disabilities. Some of the devices maybe could be hearing aids, using interpreters and all that. And then also, one of the issues we found when we visited some of the courts was that the PWDs were also lumped up in the same holding rooms when they come to court with the persons without disabilities. So those were some of the requests, that there should be separate holding rooms for persons with disabilities generally. And then finally, I'd request that before these rules are finalized, there is need to interface with the council, the National Council of Persons with Disabilities, to get more input from them. But the main comment is that the rules need to be updated with the new developments under the Persons with Disabilities Act 2020. Thank you.
Okay, thank you. Let us have His Worship LDC, and then we move to the judge. Then we shall move this side.
Okay, thank you very much. My name is Chiria Martins. I'm a Senior Principal Magistrate Grade 1. I sit at LDC. I have some comments in respect to, I'll begin with mobile courts. Under the objective, I'm making a proposal that when you study the trend of rule of law, and perhaps maybe observance of rule of law, you realize that of late, it appears people fear law enforcers than the law itself. For example, if you look at how law enforcement agencies move in town, once the hawkers see them, they run away, meaning they know the law is there, but they don't respect it. So, if we are making mobile court, in my view, we are trying to boost enforcement and observance of rule of law, because our presence in these areas, it means that people realize the law has come to us. So I'm proposing that we could have that as another objective. Then the other one is, when we look at our reporting tools, we normally have civil, criminal, traffic matters. Now, when you look at the trend, like last year during Christmas, you realize that we had a lot of traffic accidents on the roads. And this court coming on board, that means it is timely. So I expect that it will be very handy in handling some of the traffic cases. So I'm proposing that for avoidance of doubt, probably, much as traffic matters may be regarded as criminal, maybe we may specify that even traffic matters. Then on the definition of mobile courts, when you look at the definition, where it starts with, where it begins with, it also means the stationing of a magistrate court or the high court. I would propose that where after a magistrate court, if the intention is to have a magistrate court, have a mobile court within the area of jurisdiction, we specify so, such that we don't have a magistrate probably crossing over to another jurisdiction, which may be an issue of territorial jurisdiction. Then a quick one on the one of disabilities. When I read through, I formed a view that, like how we pointed out in the issue of the child-friendly rules, we need some of these procedural aspects to be detailed. For example, when you look at Rule 10, pre-court procedures, we are trying to say that, for example, where a court establishes, that is under sub-rule 2, where a court establishes that the arresting officer did not provide any such services in sub-rule 1, and it is of the opinion that the accused person needed such services, court shall quash such statement and make appropriate orders. My suggestion is that before we blame the way the police has handled these people, can we therefore come up with suggestions on what is the best way for them to handle, including recording confessions, making statements, such that by the time we blame them as judicial officers, they have a detailed procedure under these very rules on how they should have handled the cases. Thank you very much.
Yeah, before the next speaker, we have Justice Wangutis online. We'll allow him to make a comment. My Lord, you are now cleared. Once again, he has been unmuted. Yes, LDC.
Not LDC.
Please.
Thank you, Your Worship. My name is Ivan Engoru from Makerere University. My comment is also on the disability rules, and specifically Rule 22. First, allow me to thank Justice Ketirima for his paper. And I want to applaud judiciary intervention in making justice accessible to persons with disability. Dear participants, my comment on Regulation 22 is that while it is okay to make as many interventions as possible for persons with disability to access justice, I think upon conviction, the conversation is quite different. My first proposal is that when you read Regulation 22 in its entirety, it almost ties the hands of the judicial officer to ensure that the person is given a non-custodial sentence. I want to propose that there might be need, my Lord, Judge Ketirima, to cross-reference this regulation with sentencing guidelines, which are already in force, but generally to try and protect the judicial function of the judicial officer in search for a proper sentence, which has a substantive provision. As is, my view is that we then tend to focus more on this convict who has some disability and leave out society, leave out the victim of the crime. So that might not order well with the 4 principles for criminal justice system of deterrence, retribution, rehabilitation, and prevention. So I want to suggest that maybe this is something that we need to consider. As a school of law, Your Worship, we are going to make a formal submission on this particular regulation, together with, I think, on plea taking and plea bargain, so that we can support the process further. I thank you.
Okay, let us again have Justice Wangutis. My Lord, you are on. Let us have the volume. My Lord, are you with us? My lord, are you in? Please, my lord, we are listening to you, but you cannot be heard. Okay. Let us have Justice Mtonyi, then we shall move this side to Justice Chiriawire and Mr. Kule Lubengula and summary, and finally, at your end. Oh, there's also Justice Stephen Sati.
Thank you, moderator. I'm on persons with disability. My concern is on Rule 11, ability to stand trial or to participate in court processes. And then it seems 11:11 and 11:19 are in contradiction. Now, since we have the requirement of filling in this police form 24 for suspects, and on that form, there is where they have to indicate the mental capacity of the suspect. Why would we wait until this case has come to court? If we are to help people who are mentally sick, then it should start right from the police. That if the police can establish that this person is mentally sick, then the process should not come up to court. Now, when you look at 11, sub-rule 11, 11, sub-rule 11, it talks of acquitting a suspect, someone when it is proved that he is mentally sick. Now, when we look at 11:19, that if the prosecution meets the standard of proof that the accused at the time of committing the offense, despite the impairment, now we know that he's a mentally sick person who should not be criminally liable for his act, intended, was negligent or reckless, and knew what he or she was doing, the accused person may be convicted. Now, this one is a contradiction with 11, sub-rule 11. If he's mad, I'm talking of mental illness, then I don't know what we shall use to determine that this madman actually intended. We have qualified him as a person who is mentally incapacitated. How shall we use, what will the prosecution use to prove that, yes, he's mad, but he intended? So that's what we need to reconcile these two, so that if he's mad and he cannot be held. If he's mentally challenged, okay, using the word, he's mentally challenged and cannot be held responsible for his conduct, then let it be. Not, again, bringing in that if he intended, the mentally challenged person may not intend to do anything. Then, for the pecuniary jurisdiction, I know we are moving, and I know we shall not amend these rules very often, and I know we are really going, taking the courts nearer to the people. But my proposal is we would go with the highest so far, 50 for G1s, then 200 for CM, so that we don't have to keep amending, but we can put there proviso that as we have these rules, since High Court has unlimited jurisdiction, they deal with their current workload. So with the time, High Court will still have cases, and then the jurisdiction, the Chief Magistrates Court and Grade 1 magistrates would also deal with the new cases, so that when you are filing a new case, you don't come to the High Court. But the High Court still has, so it will not be redundant. And with the time, because land, for instance, land increases in value, it appreciates in value almost every day. Shall we be going back to make new rules? So let's go for this 50 to 100, and we see, so that we don't amend in the near future. That's my proposal.
Let us hear from Justice Chiriawire. inflation rate is also high.
Thank you very much. I'm glad we're not dealing with mad people. But I wanted to make a comment on mobile courts, and I'd like to agree with His Worship Chiria that we can have a primary objective of getting these courts, mobile courts, into remote areas, refugee camps, and places which are not easy to reach. But I know that in Kenya, they also have mobile courts in areas where they have regular courts. And especially in the area, this is what tickled my mind. For example, in traffic, they have, it almost looks like a kangaroo court, but it is not, because they stop you on the way, and the court is right there. The witnesses are all what? There. Available. And the matter is handled expeditiously. Those who don't want, there's also a lorry to assist them to go where they are supposed to go. I'm thinking that we should use all the possible benefits of these innovations, all the possible facets of these innovations. And I think mobile courts should become a normal feature of our courts. You know, if we are talking from the first paper I presented, if courts are becoming virtual, why are we still hung up on courts being in a particular place? The courts should be, we should move courts from being a location to courts being a service. I think this is what is happening, that courts and the provision of judicial services is really a service like you can get everywhere else. So I'd like to expand the objectives to not just hard-to-reach areas, but wherever the courts may feel that they need to set up and there's no court structure, the mobile courts should be able to go there. Now, on jurisdiction, we have had a game of table tennis on this thing for a long time. And I am wondering, unfortunately, we don't have the table that had been promised. CR promised it will come from somewhere, but it has not. To see these comparative figures, I do understand that we may be making big leaps, but sometimes I wonder when we say, okay, 100 million or 200 million. I think 200 million at our exchange rate today is about what? About 50? About $60,000, perhaps the value of a Prado. It's about 30,000? It's about 60,000, yeah. So it is the value of some not terribly expensive new car. That's what I'm saying. And this is where we are putting the cases in the High Court. You put all the processes that we have, all the manpower that we have, and we're resolving a problem worth the value of a Toyota Corolla. I don't know. We need to be more efficient in the way that we handle it. So I'd like to suggest that if we had that analysis up, I would also go for a higher figure. But we can reach it progressively with training and with better facilitation, so that we allow the courts to the magistracy to handle some of these figures. Also, I would have liked if the committee had looked at some comparisons let's say, in the region like Kenya? We did. And what did you find in terms of? Kenya is 700. So you can see we are still low. So I think my argument is still, let us go for the higher one. Thank you.
Let us first hear from the other group, then we shall come to you, my lords. We have, I don't know how to call you, your worship or council, Kule Rubengula, the most recently retired chief magistrate, now council. What do you propose?
Thank you, moderator.
We can even shoot it to 500 million.
Exactly. Once again, Kule Moses Rubangula, retired chief magistrate, but now council. I have my comments on the three rules. The first one about the people, cases of persons with disability. We had a scenario where there was a murderer. He would murder people and in the pretense that he was mentally confused. So he would be taken to court and then he's released. And the residents proposed that he should be maybe remanded or sentenced to a psychiatric hospital. And now here I'm seeing Rule 11, subsection 11, then Rule 22, sub-rule 5, all are protecting such a people and they are not protecting the society. I'm in agreement with the precurrent speaker who was saying we should balance the boat and we look also at protecting the society. Such a people, that rule should be adjusted and include that magistrates or judges should at least be allowed to remand or sentence those people to a psychiatric hospital so that they can maybe get better when they are there and they protect the society. Then on the side of the mobile courts, when I was in Kamwenge, I was expressing a challenge of security when you go out and handle a case in a refugee camp or cases in a refugee camp. You find now the suspects, inmates who are in prison and which is far from the refugee camp when you are taking the services or just nearer to the people. Then again, you are taking it far away from other people because hearing a case involves many stakeholders. So we would get a challenge of transporting again the suspects from the prison to the refugee camp. So I was proposing that also it should be looked at. They should also have other mobile vehicles for such other entities who are involved in the justice, criminal justice. Because it also includes the state attorneys. Also, I don't know whether the DPP also will give them mobile vehicles. I don't know, concurrently with the judiciary. Then lastly on the jurisdiction, recently when I joined the bar from the bench, some lawyers told me that they're going to apply for setting aside the judgments I handled when I was at Mengo, the cases which were filed there of trespass to land. They say in Kampala, there's no land which can be, even if it is a small inch of below 20 million, because I was a grade 1 when I was at Mengo. They said even if it is just a boundary problem, that strip cannot be below 20 million. So they said all cases which I handled in Mengo as a grade 1, they should be set aside, even when they have reached at appeal, even after, because I was there 2015 up to 2017, that they are going to run to court and challenge all those. So I was proposing that the jurisdiction, since in the area or in the East Africa and maybe or in Southern Africa, if other jurisdictions they have a value, pecuniary value of 700 million, as how it has been mentioned. Now I propose that chief should have 500 and grade 1 300 pecuniary division. Thank you so much.
Let us hear from somebody. That is a retired Ngula.
Thank you, Your Worship. I have two comments. One, and they are on the rules on persons with disability. I am particularly, my concern is on 19, Rule 19 on plea bargaining, which says court shall inquire into the circumstances by which the accused person with disability entered into plea bargain with the aim of confirming whether the one's disability was the reason for he or she to enter into a plea bargain. I find that the inquiry is already on the negative. I think the inquiry should be whether they entered the plea bargain with an informed mind or not whether the disability is the reason for them entering there. Then it has already been said that these rules are actually one-sided, more on the accused person's side as compared to the victims, and also the general community where we also belong to. But I wanted to draw your attention to the rule on persons who have a hearing impairment or may be talking. Under Rule 20, Sub-Rule 3, it says that they should be able to communicate through a sign language interpreter. Now, in practice, we have known a sign language interpreter as that person who has studied the English of sign language of A, B, C, D at Chambogo. And those are not the witnesses or the people we interact with in court. Most of the people who have such a challenge are not taken to court. And if they are, they are not taken to school. And if a person has not been to a formal school, they cannot therefore speak the sign language of ABC in English. Can there be a provision in case somebody has not been to school? Certainly they are communicating with their relatives at home, and they are communicating and they are able to live with each other. What provision? We need to make provision for such scenarios, because those are the everyday witnesses we have, or everyday persons that we interact with in court, than the one who will require a sign language interpreter. So where a person has been to school, we can use the sign language. But if a person has not gone to school, leaving it to a sign language interpreter, there will be no communication. It will be like one is communicating in English and another one is communicating in vernacular, and it may not help to get the ends of justice. I beg to submit. I don't know whether the members are in agreement or in...
Well, Justice Kaitirima will give us a response. But before we leave that desk, Council Emma,
yes.
Chandia, what's your comment?
Thank you so much. My comment number one is indeed there are some balancing acts that may need to be looked into, especially to ensure that concerns of the community are taken into consideration while sentencing or administering justice in some of these contexts. But the bigger, I think, concern would be the form of accommodation that the judicial officer may need to put in place. I'd like to look at just a simple example of someone found guilty. Let's say they have a physical disability and they are remanded to, let's say, remanded or even sentenced custodially to Luzira or maybe any other facility. And on going to that facility, they are unable to even enter a room maybe with a wheelchair or using a crutches, the stairs are so steep. Perhaps they're unable to go to a bathroom. What are the implications for health and other purposes while serving the sentence for that person? I think that's the context in which these rules are being made. And then, again, in the circles, especially those of us sometimes that engage with this area, still find the language is still problematic for so many. And it's quick to say someone is mad, but the conventions now do require that, including a decision of the Court of Appeal, rather Constitutional Court, of using more appropriate language. So it's important that as we do conversation, we keep learning the language that is appropriate in the area. But yes, I do agree. There are contexts, again, as to, I think, earlier pointed on sub-rule 11 and 19. I do agree with Her Lordship that some tweaking needs to be done in that area. Indeed, if someone has been unable because of their impairment to make a clear judgment and then commits a crime, you can't say subsequently they intended and therefore should be held culpable. And so yes, I agree, some of those areas need tweaking. And then lastly, I think generally the manner in which the phrases are set out may need some review. Some sentences are so long, and as you do read through, you seem to be, you can easily lose the context. And so perhaps it's into the drafting that it may need to be edited in such a way that the meaning is not lost. Thank you.
Okay, thank you. Let us hear from my brother at the end, then Ayebare, then we shall come to the president of the Ghana Law Society.
Thank you, Your Worship. Incidentally, all my concerns have been catered for by His Worship Martin Kiria with regard to the definition of mobile court. Then again, Ms. Nancy Awori also catered for my concerns under the judicature cases of persons with the disability rules, because some of the legislation that we have had not been considered, so I do not want to water down the arguments that have been made. Thank you.
Thank you. Your Worship, Ayebare.
Thank you. Mine to do with judicature cases of persons with disability rules 2019. My general remark is that there is a need for a drafting expert to look through the grammar and so forth, and particularly I will make some reference. Rule 5 and Rule 27 narrowly describe the action officers in court. Somewhere they forgot that the registrar also makes decisions, and that is Rule 5 and 27. Perhaps the word judicial officer would be more encompassing than what they have put. When you look at Rules 6, 7, you will find that the plural is used. Commissioner here assured me we don't use plurals unless that's the best we can have. Then Rule 10 and 7, the headings do not seem to appropriately describe the content down there. You may need to look at the content and maybe change the headings or something. Now, Rule 11
has a number of challenges. One recommendation is that it may have to be cut into more than one rules. The other one is when you look at the first 11.1, the language may need to be changed so that it reads appropriately. If you have time to allow me to reach there, 11.1 is it starts, the general rule is that every person has legal capacity, and then it goes on. I believe this is probably the whole of that should be removed, the whole sub-rule 1. It doesn't look like a legislative sentence. Then 9 is also casually presented. It starts with such an order once given. I think it should start in a better way. The same goes to 13, sub-rule 13. Then 14, and I think 17, the words used look to be very casual, where you are talking of the opinion of court. I think somewhere I saw something like sending a suspect into custody. Yeah, perhaps some of those words need to be refined to the legal language that we use. And then Rule 14.2 it also needs to be split into ABC. And then finally, Rule 19. Rule 19, court shall inquire into circumstances by which the accused person with a disability entered into a plea bargain. I think there must be something, a provision that allows these people to enter into a plea bargain before we tell the court to look into how the bargain was made. Maybe this should be sub-rule 2, there should be sub-rule 1 that provides that these persons can enter into a plea bargain. The rest, a few of typing and so forth, which if they wish. Otherwise, thank you so much.
Let us hear from the President, and then Justice Eva, and then we shall have Justice Immaculate, and since Justice Eudes, you'll be responding, you'll make your comment as you respond. Much obliged. Oh, there are also other 2 comments from Justice Moviru and Justice Vasaza. I think that will be enough for the day.
Yes. There is an interesting statistic that the Chief Registrar gave, that if you look at the matters that have been filed at the High Court, most of them are between 50 and 75 million. So it looks like our members are trying to run away from the Magistrates' Court, that you actually have, even if the value of the land is 40 million, someone will actually state that it is 51 or 50 million and 500,000, so that I am not within the jurisdiction of the magistrate. If that is the case, then there are 2 issues for me. One, we will not sort out this problem until we have some sort of standard valuation, which we all follow. That's number 1. Because even if you increase it to 100 million or 75 million, we shall put 101 million so that we run away from the jurisdiction. So it seems that we need to address some issues, candidly speaking, around the Magistrates' Court first, before we can even progressively increase. We can progressively increase, I think, for me, 75 million as we deal with some of these issues, and then possibly see how we can get to another level.
Maybe you could tell us some issues. Why are they running away from the Magistrates' Courts?
I think from from the discussions I have with the members, I think there are two issues. One is, I think the quality of decisions coming through, and the fact that even when we are hiring, I think it's an issue of trying to see how we ensure that the best are getting into the system. So these are the issues, candidly speaking, and it's a challenge also that we need to be able to address. But I think also more importantly, we need to address the issue of having that valuation standard. That valuation standard. Even when you have the right quality and you don't address the valuation standard, you'll still see people getting out of the system. I think when you go to the chief government valuer and we are doing a transfer of land, you can put 50 million, but then he has a standard that he looks at and says it's supposed to be 200 million, you know, and he uses that for the purpose of valuation of stamp duty. So I think we may need to be able to look at that and use it and say that is the standard we must use if we are filing matters, especially in the land division. Thank you.
Let us have Honorable Justice Eva.
Problem. Can you hear me? Yes? Yes, I'll just briefly start from where he stopped that. Yes, are we really, are we just giving them jurisdiction? Are they ready for this kind of jurisdiction? I know we are safe with numbers at grade 1. Do we even have the numbers to handle at, I don't know, the chief magistrates, but my question is, are we going to just give them this jurisdiction without preparing them? But that is for us as a judiciary to look at. We'll need to train them, the way they write their judgments, and so many other things. I think he's only cracked on the tip of the iceberg, the problems that are being complained about at the magistracy. But getting back to the documents, I'll only make my quick comments on Rule 11, persons with disabilities. Rule 11, there's so much said there. It has got about 20 segments. My comments will only be on 16 and 20, as well as Rule 20, Sub-Rule 3 and 5. And some of it has been stated by the lady from the DPP's office. My experience was also with those people who are illiterate, impaired, illiterate. They cannot hear, they cannot speak, but they are not educated in sign language. We have to make clear provisions, because we tried to get experts from some of these deaf schools, but as soon as they would come, you could see they could not communicate. They could not communicate, and those people are really flushed out of the system. My other comment, it seems, the rule seems to suggest that the judicial officer will have powers at a certain point to release a person back if they find that this person was mentally impaired and did not know when they offended, and they can now send them back into the community. Yes, and I think the TIS says something completely different. And our sisters from the experts have warned us that you're not going to start making rules that are quite opposite to what the parent statutes are saying. These documents seem to be well-founded in human rights, very strongly founded, as opposed to maybe to some of our statutes. But we probably have to first look at amending the statutes before we go into using some of these rules. I'm looking at Rule 20 of paragraph 11. A key witness, if you find that this key witness is impaired, has some impairment, and they are deemed unable to understand the nature of proceedings, then you shouldn't press them, but instead you explore other witnesses. Usually these are the best witnesses that the prosecution has. So if you're going to tell them to abandon them, they are going to lose most of these trials. Instead, we should be improving, like the way we want to do, we should be improving our courts so that they can be able to extract evidence from these people, but not only to retire them, because once you retire them, then you don't have evidence. Yes, I'm looking at 25, courts to explore and permit the usage of disability enabling technologies. that may provide more functioning and independence to a person. I think this, we can work with this one to improve, we can improve that rule, because it's only talking about disability enabling technologies. It shouldn't be only technologies. Let it say and other things, because like they told you, most of the judges and magistrates who are in the field, they try to use to be innovative. We could call them innovations, so that they can extract that evidence. It's not technology at all. It's nothing to do with technology. Sometimes they invite relatives of these people who can then use their own kind of language between them. Of course, the defense then comes in to say, this is not possible. It's unfair to my client because we don't know what we are talking about. We need to explore this a little bit more because it's a big, big problem at trials. I think that is all I have to say for now.
Okay, let us hear from Justice Immaculate and finally Justice Mabiru. You may have more time when you read these pieces of rules, and if you develop any further comments, like Mr. Ngoru said, they will submit a whole memorandum. Please, you can only submit it to the Office of the Chief Registrar by the 5th of April. All those comments will be looked at and they will be incorporated. My Lord.
Thank you. Let me comment about what the President Law Society has said. People trying to put it at 51. There are so many things, 51 million. There are so many things embedded in there. One of them, people are trying to avoid paying proper court fees. Something that is valued at 200 million. You find somebody putting there, the value is above 50 million. What is that? When the registrar is taxing the bill of costs, what are they taking into consideration in relation to Scale 6 of the regulations of the Advocates' Remuneration and Taxation of Costs regulations? That is one aspect. The other comment I would like to make, Chief Registrar, when you are meeting the registrars and the magistrates, emphasize applicability of Section 11 of the Civil Procedure Act. It is very clear. There shouldn't be anything in the pleadings like the value of the subject matter is above 60 million. No, it says you either know the value or you approximate. So these issues that we are having, actually, when you put it at 100 as you propose, people will now have to pay proper court fees, and even in the pleadings, they will state the proper value. Thank you.
So, President, looks like the other side, the constituency also has issues. Okay? You will balance it. The Honorable PG has something to say. Oh, there was Justice Mubiru, then maybe we can have a comment from the Honorable PG.
Thank you very much. My comment is about the proposed enhancement of jurisdiction of magistrates. During the presentation, I appreciated the focus of the proposals to be driven by mainly two elements. It's about reduction of backlog in the High Court and also equitable distribution of workload. I suggest that conferring jurisdiction is wider than this. It's about entrusting judicial officers with the duty to administer justice. And it is guided by the 6 principles of, in the Judicial Code of Conduct. Now, these elements are driven towards one goal: inspiring confidence in the judiciary and the outcome of decision-making. That is the idea. Now, if that is the main idea, we break it down into the elements. At entry into the judiciary, someone has the academic competence, but we don't know yet whether they have the professional competence. Their integrity has not been tested, their diligence has not been tested, and so on and so forth. Now, pecuniary jurisdiction is split based on the degree of confidence that the system has built around its officers. The more you're trusted in delivery of those principles, the greater the responsibility that is conferred at that level. That is the determinant. So the study should, I suggest, first determine what is the ideal workload of a person at entry into the judiciary. How much work can you entrust with a grade 1 magistrate? This is based on the rate of filing of cases in a particular jurisdiction. We should be able to track, since the last increment in jurisdiction, at what rate have we been getting cases filed into the system. So we are tracking ideal workload. Then workforce. For a long time, we didn't have sufficient number of judicial officers. I think of recent, we've seen a considerable increment in the workforce, but we should also study the capacity of the government to increase the workforce. At what rate have we seen that increment over time, especially since the last increment in jurisdiction? I think it was around 1990, if I'm not mistaken. 207. 207, thank you very much, PJ. Now, we also track, as it has been mentioned by the President, Uganda Law Society, as well as the Honorable Justice of Appeal, we have a problem of competence at the lower levels. We have a problem of integrity at the lower levels of the judiciary. In trying to solve one problem, we might be creating or exacerbating an existing challenge. I think it is too early to make these proposals until we have had a robust analysis of all these dynamics. Do we see an increment in the levels of competence so that we confer more powers? Do we see an increment in the levels of integrity so that we devolve more powers to the lower levels? Do we see increased and effective supervision over this level? Do we see increased mentorship, building of competencies? Do we have such systems? Do we have effective processes of weeding out, I would say, or eliminating non-performers before they've done too much damage? All these are issues that we need to grapple with before we deal with devolving of powers. We are not dealing with numbers per se, but essentially we're dealing with devolution of powers of judicial decision-making from tested and tried competent judicial officers to those who are yet to prove their competencies in the system. That is essentially what we are discussing here. It's not about numbers only. It's about devolution of effective judicial decision-making that is inspiring to the population, that delivers justice to the population. It's not about taking judicial officers nearer to the people, but delivering competent and effective judicial services. Thank you very much.
My Lord PJ, as you come in to make a comment, a member of the bar sends in a message here and is asking, and I think it also goes back to what Judge Stephen Maviru is talking about. He's saying, I want to remain anonymous, but I only want you to say this, that judicial has been grappling with corruption at the lower bench when they had limited jurisdiction. When you enhance it to those big sums, is judiciary ready to counter the attendant corruption that might come through? is saying he wants a comment on that one. My Lord PJ.
Okay. Yeah. Thank you so much. The issue of enhancement of jurisdiction, I want you to appreciate. I know people have been talking of 500. That's what we don't have to go back and all the time. But I want to allay your fears. We intend to have a provision within the Act that empowers the Chief Justice to review this jurisdiction as and when it is necessary. So at whatever we agree upon, and we start with that, then if we realize we have maybe developed competence, and then maybe it can be enhanced a little bit, depending on the circumstances. So that shouldn't worry us so much. Then maybe another comment I had coming through was about the drafting. I want you to know that when we come to the Rules Committee, we go with the drafting team and the entire, legislative parliamentary council, first parliamentary council team is always with us. So whatever, here we gather ideas, put them in a raw form, and then finally they will be the ones to do the final drafting. Now, of course, there are some of the issues we did not bring here, but which we also think should be looked at. The provisions of the penal code relating to aggravated defilement. I think I raised that with the summary in the morning, but it doesn't mean that we are only going to focus on monetary jurisdiction. There are other aspects that impinge on the delivery of justice which we need to look at. Then there is of course, the mobile courts. I think I had a meeting with a team from the Ministry of Transport, headed by actually the Minister, Katumba Amara, requesting that we should revive the traffic court. I think that when the traffic court was at the Buganda Road, a lot of things did happen. And I think they were wondering, first of all, why we closed it and why we cannot revive it. Now that I'm looking at mobile courts as a stopgap measure, maybe we should take Chiria's and Justice Chiawire's view to help us in this direction. Then maybe something else for the child-friendly procedures. I sent them I sent the draft to Minister of Gender, and they have sent in comments. So I don't want to read the comments here, but when we go back to the Road Reform Committee, I will present those comments there so that we can also incorporate them into the final document. Now, you raised, I think a member raised an issue relating to integrity of lower judicial officers. I think that's a tall order. We can take a whole day discussing it. I don't want to go into it at the moment. That's the very reason why we have to be cautious as we enhance the jurisdiction. So I believe in progressive enhancement so that we don't start with 500 and then we burn our fingers and then come back to you to say, let's reduce it to 100 or let's reduce it to 50. So we shall be progressive. And since we have the Chief Justice, as I mentioned, who should be given the powers then to look at this jurisdiction progressively, then we shouldn't be worried. Thank you.
Thank you very much. Let me invite the Chief Registrar to make her responses. Your Worship.
Thank you very much, Your Worship. My Lords, thank you so much for the comments. The Honorable Principal Judge has already responded to some. I'll just be adding a few things. The first person, yes, Your Worship, Kiria and Justice Kiriabwire, your comments are well received and they will be further considered by the subcommittee, especially the inclusion of those additional objectives, as well as seeing how we make the most of the innovation. Yes, pecuniary jurisdiction. Yes, we may wish for 500 million, But as members have said, to whom are you giving it? Now, there was a question whether we compared with some countries. We did. We looked at Kenya, Tanzania, Botswana, Namibia, Zambia, South Africa, Ghana. We looked at these countries. Our key interest was our neighbors, Kenya and Tanzania. Now, Tanzania, the chief magistrate, who is a district court, is at 250 million, which translates to about our 384, you may call it 400 million. The grade 1, who is the primary court, is at 50 million, which translates to about 76.5 million. Now, the Tanzanian magistrate and the Ugandan magistrates are operating at very different levels. Let's start with the entry. When a magistrate is recruited in Tanzania, they go through 3 months of induction. They have a training school 400 kilometers away from Dar es Salaam. You go, they lock you in there, you come out as a judicial officer, refined and able to handle the 400 million. We are still grappling with inductions of 1 week, of 2 weeks if you're lucky. If some of us tell you our experience, we took 3 years to be inducted. So now give me 500 million and I begin hitting my head with it. I don't know what we shall get. So let us contextualize these proposals in our context. These economies we are talking about are a bit different, more advanced than ours. And yes, this is the first time we are having these numbers. We can empower them, but to how far do we go? So Justice Mubiru, I thank you for the points you have raised. Yes, we will look at them and we partly reflected on the same, but it has been 17 years since the last amendment, 2007. And I think it's time to enhance. If we can rotate around 100 million for chief magistrate and take care of what the president raised, which I agree with, the valuation standard, particularly for land cases, because if you get the workload, the caseload of the judges of the land division now, you know, when the registrar sent me that document, and you look at land at 52 million, 60, you know, you're like, but where is this land? So are these values correct or they are not? So those are matters we have to really consider, because even when we give 100 million for courts like land division, somebody must go back with the right value and weigh it against each case. Otherwise, we are going to have a billion-shilling case. This guy is in 98 million, and it is before a chief magistrate. Particularly for land division, something has to be done. Actually, when you open and look at their lordships with the 63 million, you're like, but where is this land? So, President, you are right. We must dig deeper into these values. And if I can share something interesting, when I was a deputy registrar at Civil Division, there was an interesting trend. Cases that had, if somebody filed a case of, say, 2 billion, there was a certain other division in that building, I'll not mention, where the receipt would come from there. The assessment would not come from our cashier. Like big cases had to be assessed at a certain court. It was something, you know, which was to me putting certain stars. So later when I begin to see 51 million, 63 million, it reminded me of some of those stars that we may be put. So standardizing valuation, so that someone says land in Wandegea, you know it can't be lower than. So if you come up with your land in Wandegea at 63, surely we know you can't find anything. So Mr. President, that is very, very key, and so thank you. Thank you very much. Justice Roswata, thank you. We should not just give jurisdiction. Are we ready? Actually, in our report, one of the things we are saying, if we are to enhance even with the 75 or 100, training must be the order of the day. You must prepare somebody for this, because 200 million is a lot of money in Kampala, but that is not the case up country. We know our people. We know the businesses they are running. If you're going to just get 200 and, you know, think it's the value of $60,000, so it looks little in Kampala, it's a car. in a certain town up country, it is what the richest person has, and that is their entire business that we need to handle a bit more carefully. I think those were all for me, and I thank you once again.
So let us also hear from Justice Ketirima. Welcome.
Thank you very much. There are lots of observations, but to be assured that, especially with the drafting and the way the provisions came out, this document will finally reach the draftsman, who will put it into a proper legal language that the lawyers need to see. So don't get so worried. As the principal judge has said, what we wanted were general ideas, and that will be translated in rules. I agree that the rules should should be aligned with the current legislation. As you could see, these rules were drafted way back when the Honorable, even the name is still there, but Katurebe was still the Chief Justice. Yes, we are not looking at this for the last time. We shall align these rules to the current legislation. And as the plea has been made, I think we should interface with the stakeholders before the final draft comes out. I think, my Lord PJ, there will always be room for us to interface with the stakeholders to come up with a detailed rules. I only wanted to make an observation on 11. That 11 came out very prominently. Everybody was talking about 11.2 and 19. Now, my interpretation of that rule, if you look at 11.2, because that's where the contradiction was being pointed out, and it provides when an accused person is brought to court, and either through the information provided to the court from the police investigations, or it comes to the attention of court through interacting with the suspect or in any other manner, that a suspect is in a mental crisis, the judicial officer shall order for the suspect to be immediately taken to a medical facility to stabilize his or her condition. There was a provision, I think, which looked at acquittal of such suspects, but that is in respect of mental disability. Of course, the discussion now should be, where do you send them after acquittal? Because, in criminal matters, there are two elements you prove, the mens rea and the actus reus. So the mental state of the person by the time he committed the offense is very critical when you are proving a criminal offense. But I agree that even if you find this person was not mentally stable at the time, do you just release him back to society, or there's a facility which you should be taken for further management? Now, if you look at 19, if the prosecution meets the standard of proof that the accused at the time of committing the offense, despite the impairment intended, was negligent or reckless, and knew what he or she was doing, the accused person may be convicted. The impairment is not limited to mental impairment. I think that's the difference there. The impairment could be in other aspects. You could be mentally alert but impaired in other respects. So in that case, if negligence is proven, then you can be convicted. I thought that was the distinction I had to make. Otherwise, it might look contradictory. Thirdly, is that I think we should now, I was thinking, now with these rules, we may have to interest maybe the Prisons Authority in their way of planning. Is it possible for them, for example, to put up a structure that's for the persons with disability that would cater for all these challenges, so that we have a change in policy? That for every construction we are going to make, this should be in mind. And I think that should be the law. And I'm sure with even building approvals now, if there's no provision for the persons with disability, in most cases, they will not approve of those structures. So with even government structures, there should now be a provision, because yes, we are saving society, but this person with a disability is still a human being at the end of the day. Even if he's convicted, you want him or her to be provided by the basics. Do not accelerate this person's death simply because you want to save him from society. The argument should now be, can we make provision for this type of people in the facilities we have? I think that should be the argument. So that if you actually want to convict this person and send him into custody, there should be a facility to accommodate such a person. The rules seem to be tailored to people who are offenders than victims. I want to believe that we are balanced. The fact that we are providing an environment where the victim is able to testify and prove his or her case, and that environment is there and the facilities are provided, in a way, there is a balancing act. That the victim should be able to testify and use evidence that will enable the court to convict the offender. And I want to believe that, actually I am worried about the capacity, but for the provisions I think they are reasonable. Okay? Actually, if we were to implement this document as it is, that would be good enough. The discretion, for example, that a magistrate or judicial officer should be able to determine a facility where the trial is going to take place is a big decision that has a financial implication. And the rules are providing for that. And I gave an example that I can now decide to have a trial in Hotel Africana if I think it's the only place that can make provision. So we can improve on these rules, I agree. But I think there's a balancing act now, and there's some guidance on how this should be done. And yes, we need, I think, to give details on how, like, the police should handle these suspects. We should not just make a general rule and say the police should handle these suspects in this way. We should go ahead and give details. If we are dealing with a person who's, say, visually impaired, how do you deal with that person? If you are dealing with a person who's physically impaired, how do you deal with that person? Which facility do you place him in? At times, that detail is needed for our policemen and women. Now, there was also what about looking at trained interpreters vis-a-vis offenders who have not gone to school. And that's why there is provision now for a support person. In a criminal trial, we are allowing the accused to actually pick 3. And I'm sure one of the roles of these support persons is to interpret to the court what the impaired person is communicating. Okay? If I've grown up with this person, I know how he or she communicates. This supportive person, on top of the skilled interpreter, would assist the court to know what the impaired person is communicating to the court. And I think that was the rationale of having these people provided to the victim. By and large, I think there's still room to improve on this document, and I'm sure there will be another validation. There will be another opportunity to look at some of these rules, to align them especially with the recent legislation. The definitions of some of these terms have to change, and I am sure at the end of the day, we can have a good draft or a good rules that the people with disability can hold us accountable as courts when they are looking at a fair trial. This is basically about a fair trial. What is in place for this person in order to ensure a fair trial? I thank you for listening to me.
Let us give another hand clap for the presenters. And we have A number of comments coming through online, and the Secretariat will be picking them and will be submitting them to the committee. My lords and your worships, our invited guests, we want to thank you very much for giving us all this time and your patience. At this moment, allow me to invite the Honorable the Principal Judge to make his closing remarks. My Lord, you empowered me, and I'm exercising the jurisdiction. Thank you.
I actually thought someone else was supposed to cross since I opened. Now I gave you powers, now you have misused them. I expected someone else to cross. But anyway, nevertheless, I think in the interest of time, let me not stretch the... of course, I think I must thank you sincerely for the contributions, ideas that you have generated in this room. You can imagine when we are in rural reform, we form committees, a committee goes and drafts, they bring, we chase them, they bring again, we chase them. Finally, we say, okay, now this is acceptable. Now we come here, they chase all of us. That's how it works. Eh? And now if we were to give to the first parliamentary council these documents, they would tear them apart completely. Of course, they would maintain the ideas somewhere, but then they would tear them completely. So I thank you so much for attending, and kindly always find the time when we call you for these exercises. I know, for example, issues to do with the persons with disabilities, that we cannot say we can achieve all this. It will be progressive realization. For example, changing all the buildings we have at a go, like our courts, to change them at a go would require a lot of money. Now, when you want to pass this legislation, then the Minister of Finance will not issue a certificate of financial implications. Or in other words, he will issue a negative one, I think. So we have to be very careful. But progressive realization, if we have that cross, then we can achieve. Of course, even the mobile courts can actually provide this environment of where you can deal with the people with physical disability. I know the mobile court, for example, I saw in Temeke, it has a system where a person with disability comes and sits, it lifts him or her, and then puts him in a certain chair. It even has a toilet for people with disabilities. The same court. So maybe Justice Ketirima, you don't have to come to Hotel Africana. We shall drive the van to family division, the truck, and then you use that same truck. Then interpreters for the deaf and dumb. Of course, this one is a very big challenge. I don't know. I remember one time when I was handling a matter in Mbarara, I had a lady who was both deaf and dumb. I don't know whether those are the right terms to use. I have to be very careful. Then it's only the mother who could understand her. So now, you know the risk you are running, relying on the mother of the defiled. But I said, now, what do I do in these circumstances? I said, okay, let me allow this evidence, and then I will, caution myself, and then, of course, rely on some additional evidence. And that's what I did. Maybe like some form of collaboration, really. And then I ended up convicting, but I'm always worried that the day Justice Ruswata looks at it. So these are realities which you face in the field, especially about people with disabilities. These are realities. Okay, thank you so much. I think we can close it at this. We have other rules which we are developing in the Rules Committee. So after this set, we shall again come back for more. Thank you so much. And don't leave the tea here. I see some tea prepared. Let's have it. Thank you.